boldip.com.
Hi, I'm JD Hoovener, and I'm the founding patent attorney here at Bold IP. It's an honor to spend some quality time with you today to share with you how we do IP law a bit differently than the rest. Bold IP is an agile law firm whose mission is to serve the bold and the brave. That means we strive to serve everyone, from solo entrepreneurs and small businesses to Fortune 500 companies. Bold IP focuses on intellectual property law, including patents, trademarks, copyrights, and trade secrets. Our team specializes in aerospace, healthcare, and software. We have industry-leading experience in those technologies, and we love seeing innovation in those fields. I want to introduce Bold IP, Bold Ideas, The Inventor's Guide to Patents. This book is out on Amazon.com and is available at your local bookstore. Author, J.D. Hoovener, yours truly. Our firm connects with small businesses and their individual inventors. We help them make that big decision about whether to move forward with that bold idea. Give us a call or send an email and set up a free consult today. Look forward to hearing from you. Go big, go bold. I want to start today with walking you through what I show each and every inventor that meets with me regarding patents. And what is the process? How does it work? And we break it down in an ABC format that's very easy to follow. This page is a little busy, but this is a simplified version, believe it or not. So without further ado, let's dig into this. So when I work with inventors, what's the first step that I talk about? Well, it's patentability. And that usually means, is it novel? Is it one of a kind? Before we even get there, actually, I discuss the initial considerations. Is it even eligible? Is it patent eligible under Section 101? What are the opportunities here? How many inventions do we really have? And how does this fit into a business plan? Separate from that is the inventorship. Is it just the one inventor, or is there a business at play here that there might be an assignment there too? In line with the opportunities, but what are the long-term business goals? Is the inventor looking to manufacture the product on their own, or are they looking to actually license out to a larger entity? All these are important considerations at that first meeting. So assuming the inventor wants to go ahead, let's do that patent search. That's usually critical to making sure that we know what is out there in the prior art, in the field as it is today, before we file. That way we'll know, A, should we even file to begin with? Meaning, is there a patent or a publication out there today that is exactly on point? Or if there's not, how close is it to the invention that the inventor mentions? So we know exactly what the scope might end up looking like, assuming we found everything under the sun. Let's assume a green light, that if the patentability search comes back and there's nothing quite like what the inventor has, great news, right? We usually move ahead to the provisional patent application phase, and that's here in green. So we start about 3 to 4 weeks after that patentability search began. And at that point, it takes us another 6 or so weeks to develop that application into a position that we could then file it. So you can see here, there's 4 main bullets. The timing we just talked about. As soon as it gets filed, at this point here, in the finish line of the provisional patent application, you get what's called patent pending status. To get that, you've got to have an enabling disclosure. This is so important, and this is why so many inventors that try to do it themselves fall short. The written description has to be written in such a detail that an inventor just like them in the same field would be able to take that writing and go build it and make it themselves. It's got to be instructional, folks. Exactly as you would need it to go build it yourself. In that specification and drawings is also included in the provisional patent application. The drawings are included if they're needed to understand how to make or use the invention. That locks in the patent pending status for 1 year, and that's the maximum. You can see this line here. A non-provisional patent application must be filed within 1 year of that provisional filing date. Usually we start about 3 or so months before that year is up, at about the 9-month mark, to start writing the non-provisional. So what do you do in that 9 months? Well, you hit the streets. You no longer need to keep that patent a secret, the application rather. You can go tell third parties, take it to trade shows, and even begin selling your invention, because you've got that priority date right here at this B, which is the submittal date of the provisional patent application. So once you, after 9 months, you've most likely got a lot of good affirmation in the market. People want to buy the application. People want to buy the product or system or service that you've invented. Assuming that's the case, more likely than not, the invention has changed, and for the better. But because those changes have not been input to the provisional, they need to be updated in the non-provisional. Here's where we make the changes to the drawings in the spec. We also add in the claim language. This is super important. This is, in fact, what will define your patent. And it's the domain of patent attorneys, and it's one of the main subject matter that patent attorneys study when they study for the patent bar. How to write claims. Formal submittal to the patent office. This is the final application that will get submitted to the examiner. This is the first application that they will see when it comes across their desk. It's critical that it's in the formal, efficient manner, ready for examination. And that's all for the patent application process flow. Go big and go bold.
Go big, go bold at boldip.com.